to the webinar we hosted a couple weeks ago on Assembly Bill 241. And so our goal today is to try to, first of all, we'll get everybody on a level playing field with some recap of the bill, but really to try to answer questions that we have received after the webinar, between these webinars, and sort of talk through additional questions that may come up during this session. I can say that since the last time we met, there hasn't been any real new guidance or information coming out, but I think all of us as individuals in this field are just still thinking through strategies and talking with folks. So as we move forward, I think new questions and situations do arise. As we did last time, based upon the number of callers into the webinar, we do have everybody in listen-only mode. So hopefully you can hear me clearly, and if you have any questions or concerns, certainly use the question or the chat pane in your webinar to ask those. I am sitting here today with Colby Rivetto, our Director of Marketing, who ensures that I will not have any hiccups in technology, as well as to help me monitor the questions that come in so we can make this a real good investment of time today. For those of you who I have not had the pleasure of speaking with in the past, I would like to introduce myself. My name is Kirsten Gould. I am the Vice President of Human Resources for Live Home. I have been in the elder home care industry for over 10 years, and I have some additional experience, about 5+ years, working in the senior health care industry. I have a master's degree in human resources design, and I've been a certified senior professional in human resources with a specific California state designation since 2001. I would like to provide a disclaimer today to make sure that everybody on the call does understand that the material in this presentation is provided for informational purposes only, and it is based upon our research and understanding of this law, AB 241, at the time of publication of this webinar. Although we've taken great care to ensure that this information is prepared accurately, all attendees are strongly encouraged to contact their own counsel to discuss their particular circumstances. Neither myself, Live Home, nor its representatives can give legal advice. Okay, so as I mentioned, a portion of this webinar is going to be dedicated to answering your current questions. So I would encourage you to use your chat or question feature as we move along, and hopefully we'll get to everybody's questions that we are capable of answering in the latter half of the presentation. So let's briefly touch upon the highlights of Assembly Bill 241 to make sure we're all on the same page related to its provisions. We know that Governor Brown signed the bill on September 26, 2013, and it creates the right to overtime pay for individuals who are defined as domestic work employees. These folks are any individual who performs domestic work for a household or for an individual in a household, and it includes live-in domestic work employees and personal attendants. It's important to note that in the definition of domestic work, it does not include the care of persons in facilities, including but not limited to residential care facilities for the elderly. And this is an important point I wanted to make sure folks knew, because we had a couple of questions from people who are, administrators or work in RCFEs. So this is an important provision. We know that this bill goes into effect on January 1st, 2014, and what it requires is that domestic work employees, as we have defined them above, must be paid time and a half their regular rate of pay for all hours worked over 9 in a day and over 45 in a week. For those of us familiar with overtime laws, generally in the state of California, we recognize that this is a difference from the 8 and 40 daily and overtime requirement outside the home care industry and in many other industries. So this creates sort of another layer of overtime pay that we as employers need to be concerned about. Importantly, there is no obligation to pay double time. nor is there any obligation to provide meal or rest breaks under AB 241. So, you know, we're worried about a lot of things, but we're not worried about double time. We're not worried about meal and rest breaks as it relates to this particular bill. Additionally, we understand that the law applies equally both to employers of domestic work employees that are third-party agencies, as well as those who are private individuals in private households. So if you are a loved one of a family member who receives care in their home and they pay for that care privately, the person's not employed by a third-party agency, that person is entitled to overtime in the same circumstances and to the same degree under AB 241. What are some notable exceptions to this bill? Notably excepted from the overtime provisions are any person who performs services through the IHSS program, that's in-home supportive services, and that program is for Medi-Cal eligible individuals. Any close family members of the domestic work employer, so if there is a parent or a grandparent, spouse, or sibling who is performing the care for the employer, then they are not entitled to overtime under AB 241. Also exempted is any person who's employed by a licensed health facility defined by Section 1250 of the Health and Safety Code. These are generally acute care hospitals, SNFs, intermediate care facilities, and facilities of that nature. January 1st of 2017 is the sunsetting date of AB 241. So after that date, this law will no longer be in effect unless it is extended or repealed prior to that date. For those of us who are interested in a snapshot of the upcoming changes that will impact the home care industry and individuals who are engaged in the care of older folks, let's look at the next coming years. 2014, we see that AB 241 is effective. That's January 1st. Overtime will apply, and it will be applicable for hours worked over 9 in a day and 45 in a week. In July of 2014, the minimum wage in the state of California is going to increase from where it is currently, $8 an hour, to $9 an hour, and that is courtesy of Assembly Bill 10, which was also signed earlier this year. 2015, we have a few things happening. We've got the elimination of the federal companionship exemption. This is being eliminated entirely for third-party employers, so that means across the nation, third-party employers of home care workers will no longer be able to enjoy this exemption. And this means that overtime will be applicable in the state of California for all hours worked over 9 in a day and 40 in a work week. So, shortly we're going to have to change that weekly overtime requirement, because what the Fed does under this elimination of the overtime exemption is more stringent and favorable to the employee than our California requirements. So we as employers must follow that. Also, for individuals and households, families, loved ones of clients who receive care, although they're not third-party employers, the scope of the work that affords the companion exemption is going to become significantly limited. And that means that families who nationwide enjoy this exemption currently will only be able to do so under very limited circumstances. So really, what this does is it really eliminates the exemption on a national basis for both employers as well as private households. We also are aware that unless there are any changes, and it's a topic of hot debate currently, that the employer mandate under the Affordable Care Act will become effective January 1st of 2015. And while that is outside the scope of today's presentation, as employers who may employ more than 50 individuals, we know that we will be obligated to provide affordable health care coverage for our employees, including our variable hour employees, which in most cases is going to include caregivers, And that may result in additional costs to us that we will need to plan for. 2016, January 1st of 2016, the minimum wage will increase to $10 per hour, again, courtesy of AB 10. And then we also have, I think, a bill that went into effect or that was signed that many of us have kind of overlooked because we've been so shell-shocked by AB 241, and that is the Home Care Services Consumer Protection Act, which is essentially a fairly, I don't know, it's not terribly robust, it's not terribly burdensome, but it is a law that is going to regulate the home care industry to some degree in the state of California where home care was not previously regulated. This was initially signed to go into effect January 1st of 2015, or it was drafted to go into effect in 2015, and when Governor Brown signed it, he changed the date to January of 2016. What happens in 2017, I think it's anybody's guess. If it hadn't been repealed or changed prior to this point, we should see AB 241 sunset. What does that mean for overtime pay? What will overtime pay go back to? Will it go back to, will we have the personal attendant exemption in whole or in part, although that may be exempted by the elimination of the federal exemption? Will overtime be applicable and paid for 8 hours in a day, 40 in a week, 9 and 40, 9 and 45? I have no clue, but we just know that it's going to be a challenge. And as far as I'm concerned, folks, 2017 may result in my elective early retirement in the home care industry because I will be so exhausted contemplating all of these changes and figuring out how we continue to successfully serve seniors in their own homes. People tended to like this, this little chart, which really is just a great example of the increasing cost of wages that would be applied under a particular example from today in 2013 and out through early part of 2016. So if you just look at this example, and what we're looking at is the caregiver who is working 12 hours per day, Monday through Friday, making current minimum wage. So we know not all of our clients are in this situation. They tend to need greater care than this, but you can see the increase in wages both on a daily and weekly basis that will be required under this scenario based upon all of the changes in the law moving forward. And the changes in the law are relative to AB 241, the elimination of the overtime exemption, as well as the increases in minimum wage and the elimination of the federal companionship exemption in 2015. So this is, as I said in my first webinar, very unprecedented. I think it reflects about a 46% increase in wages over a very short period of time, which, as we know, results in increased costs to our clients and consumers. That is just a little recap on AB 241 and its impact to all of us who serve seniors and have seniors as loved ones. I want to start addressing some of the questions that we received via our website. And we heard from a few folks who were concerned about liability for wages. There were a few professional fiduciaries who attended our webinar a couple weeks ago, and some really great questions came out from these folks around liability. So I wanted to talk briefly about that. The liability issues are not specifically related to AB 241. These are general liability issues for failure to pay wages appropriately that have always been contained within the California Labor Code. So let's take a look at some of the issues. Failure to pay either minimum wage or overtime. Well, let me back up. Failure to pay minimum wage on its own subjects the violator to a couple of things. Fines, potentially imprisonment, and restitution or repayment of the wages owed when they have not paid minimum wage appropriately. You should know that you cannot enter into an agreement with your employee as an employer to pay a wage or to receive a wage that's lower than minimum wage. So even with that agreement, everybody's okay with it, they want to work together, that is still illegal, and it would still subject the employer to these sanctions. Additionally, employees who receive less than the applicable minimum wage or overtime compensation will be entitled to the wages owed, so the difference between what they were paid and what they should have been paid, including interest, reasonable attorney's fees, and maybe there are attorneys on this call, maybe there aren't, but I don't know any attorney's fees that are reasonable, and the cost of the lawsuit. So you need to be aware that the cost of these claims going to legal action can be very dramatic. Now, how long are you subject to these types of concerns? Well, we generally think that the recovery of back pay and that these claims can go back 3 years. Generally speaking, that's accurate. But recently, well, probably 12 or 13 years ago, I should say, that's not that recent. But the California Supreme Court found that a failure to pay earned wages violates the unfair competition law, and that violation allows an employee to file and collect up to 4 years of back wages. So really, all of us as employers are on the hook to pay back wages owed for up to 4 years. This came about as a result of a case that was Cortez versus Purolator air filtration products. And I do think that was probably early 2000 that happened. So lots of liability there. I think that for those of you who secure care for clients, if you are a professional fiduciary, you're responsible for, acquiring the care, maybe through an agency or private individuals. If you are concerned about their practices and what liability may fall on you, I would certainly suggest that you go back and review any of your agreements, the contracts or written agreements for services that you may have signed. I think that it would be very prudent of you to have a conversation with that entity, that home care agency or whomever, to ensure that they are paying wages appropriately. I think it would be a stretch for a fiduciary to be pulled into a wage claim because the employer of record is generally liable for those wages, but you just don't want any vicarious liability. And certainly if you know that there's something untoward or amiss in the payment of wages, that may put you in a difficult position. So I would definitely go back to your written agreements, and I would go ask the question of the home care agency and make sure that their practices are appropriate based upon not only current law, but the laws as they change moving forward. A number of people, from my understanding, probably loved ones of their elder family members or other individuals have asked, repeatedly about any alternatives to paying the increased cost of overtime. And, I think that, that's what all of us on this call are doing. And certainly on other calls, we all here at Live Home are attending as many conference calls as we can to see what else is out there on the horizon that may help us create the solutions, the affordable solutions that we all want to create for our clients. So I think the dialogue needs to be open as we move forward with this new law to try to determine what lawful alternatives we have. Some of this on this slide that you see today is a little bit of a recap from what we discussed 2 weeks ago, but these are really the alternatives that we have as employers to these domestic workers to try to mitigate cost increases. Not really a mitigation option, but a cost-sharing option is to pass along some of the cost to the consumer. How much of that do we pass along is a business decision, but is there cost sharing, or do we need to pass along 100% of the increased cost? Makes it hard to run business at that point. We are, as a business, certainly looking at different staffing patterns, meaning we are looking at the opportunity to hire additional caregivers where we can to avoid or reduce the overtime liability. Obviously, some of the ways that we can do this is to, maybe rotate in 3 employees working 8 hours each to cover a 24-hour shift. Or, assume that you're going to pay a little bit of overtime and have 2 caregivers who each work a 12-hour shift, 3 hours of overtime entitlement for both of those individuals on a daily basis to cover that 24-hour shift. Lots of different ways you can carve it up, but the bottom line is where you need a 24-hour period of coverage, that is just a significant challenge. Restructuring compensation, as we know as employers, it's fairly easy to restructure compensation for new employees coming into your organization. The wages are what the wages are. But where we have our current caregivers working with our clients in a variety of capacities, restructuring compensation can be a challenge. And so what I suggest is certainly to look at everything on a case-by-case basis. I don't know that I would necessarily endorse a blanket sort of change or reduction in compensation over the entire organization. That could certainly be problematic. But I think all issues around reducing compensation for your current employee population, your caregiver or domestic worker population should be run by council. You need to know where the potential landmines are. You need to, certainly be sensitive to your employees through the communication process and give them some notice. But, you just really want to do this in a thoughtful manner for all parties. And then finally, and I think what our leaders in Live Home have been doing now for, a number of weeks, a month and a half or so, 2 months since the bill was signed, is that we're looking at every single client's care plan. We triage them, of course, look at those folks who would be impacted most greatly and sort of decreasing from there to lesser impact. And we started really examining how a care plan could be changed, inputting additional resources, accessing different resources, changing the scheduling to try to provide options that would be palatable to our clients and their concerned loved ones and certainly their payers. So some of the things that we all need to be examining are those community resources. Do we have a way, can we minimize caregiver hours by getting the elder person into an adult daycare program, for example? Are they capable of attending one of those programs? Would they benefit from one of those programs? Is that a viable alternative to keep your agency off the clock for that period of time? Are there any additional family members who maybe we as a company thought weren't involved before but could be involved now? Is there anybody whose life circumstance has changed who could step in and provide some care for mom or dad, where they weren't before simply because they weren't asked? If your senior client or family member is eligible for Medi-Cal, you might want to look into the IHSS program to see if they may qualify and if that could be a place where you could access care for your loved one or your client, because as we know from prior slides, those workers are specifically exempted from the overtime requirements. And finally, are there any other creative solutions, technology that could help this person remain safe in their home? So, for example, I know in, obviously the home care industry, sometimes we provide live-in care not because it's absolutely necessary. The person doesn't necessarily need 24-hour assistance, but it can be a convenience. It's a convenience to the caregiver perhaps, it's a convenience to the client, it's a nice to have. But where a client doesn't need that round-the-clock care, can you provide some technological assistance for some hours, 4, 6, 8 hours of, maybe the sleeping time or some other time per day. Maybe they have a panic button or, a life alert pendant or something of that nature that can assist them if they fall, get them emergency assistance quickly where they don't have a caregiver in place. There are probably other technological solutions that we could consider around the house, door alarms, door monitors, window monitors, things of that nature. But obviously, this is not a solution that's going to be, able to be put in place for many of our most vulnerable clients and seniors. A few folks, I should just mention, I have gotten emails from individuals who are curious about live home strategy. And all I can say to you is that we are examining each and every one of those strategies per client. And we just don't have a blanket solution. We're really looking at each client individually and trying to determine the best solutions to present to him or her or to the family members. I have also gotten some additional questions. People want to confirm, I think, because they're just, simply flabbergasted by the prospect that this could apply to, employment, private employment in the home where a third-party employer is not involved. And so I just need to confirm for everybody that, yes, this law does apply to individuals who are hired privately by a household where that person does fall under the definition of a domestic worker. So make sure that you are, advising your clients, if you are a professional fiduciary or somebody else who knows that there is a private caregiver in place, you may be the person who needs to sit down and make sure that that payment is happening appropriately. You could certainly look for additional assistance in that regard to help make sure that pay is happening. But families need to know that this is an obligation that rests on their shoulders as well. A few people asked about whether or not, what does this mean about meal times? How many hours must a caregiver get free of duty? And I should tell you that AB 241 is silent on those issues. It only regulates pay, and it requires overtime pay. So it doesn't talk about other terms of employment. So really, family members and individuals who hire the private care, it's really up to you to determine how meal periods are taken, rest periods are taken, how you handle sleep periods, etc. That's really not what the law is regulating at this point. For those of you who may be individuals hiring caregivers privately, I'd like to direct your attention to the IRS website at irs.gov. If you Google, not Google, but if you do a search on that site, you can find Publication 926, which is the Household Employers Tax Guide. Not only does it help individuals determine how to pay and remit tax for household employees, but it also talks about other issues such as, how do you ensure that they are legally able to work in the United States, and, when are taxes payable, when are they not. So it's a really great publication that will help guide you through some of these issues. There are record-keeping requirements that you need to be aware of. So that really does walk you through some of those things, and it's a great resource for individuals who are in this situation. The question about 24-hour live-in care continues to arise. And again, I think it keeps being brought up because all of us want to believe that there has to be a better solution out there than dramatically increased costs to our most vulnerable citizens. I can tell you, as I shared with you in our last call, there has been no magic solution presented. There has been no additional guidance on this matter that leads me or anybody else to believe that there is anything we can do other than pay regular pay and overtime pay as required by Assembly Bill 241 for all hours worked. AB 241 is silent on the issue of living care. It doesn't talk about it, doesn't address it. So the commonly held understanding for those of us who are concerned is that all hours are compensable under the 9 and 45-hour overtime requirement. Now, what many of us in the home care industry have relied on is the existing case law, which allows employers to make a deduction or to exclude, is a better way of saying it, to exclude 8 hours of sleeping time for shifts that are 24 hours in length or longer. Now, that's kind of an important distinction, and I don't think I really clarified that in the call 2 weeks ago. This is only allowed for shifts that are 24 hours or longer. There is no sleeping time exclusion for shifts that are 23 hours, 22 hours, 20 hours, etc. Some people might think, well, if I prorate it, you know, maybe I prorate it down to 6 hours of sleep time or 4 hours of sleep time I can exclude. You can't. There is no sleep time exclusion available under the regs and under case law for shifts that are less than 24 hours in length. Now, what do you need to do or be mindful of if you want to exclude 8 hours of sleeping time from the 24-hour shifts? You need to have an agreement between the employer and employee that sleeping time will be excluded. It does not have to be a written agreement, but you know that the burden of proof falls to the employer to show that that agreement was reached. So you should have some written agreement so you can prove that if need be. Adequate sleeping facilities must be provided. I do not think the phrase adequate sleeping facilities has been defined, but you know, I mean, does that mean a couch? Does that mean a private bedroom? Does that mean a cot? I don't know, but when you think about the term adequate, you might want to talk to your counsel about what that means. Importantly, the employee must be able to get at least 5 hours of uninterrupted sleep time in order to be able to claim the sleep time exclusion. If they are interrupted and do not get at least 5 hours of continuous sleep, you must pay for that entire period of time. This is important to know because for home care agencies who are thinking about using the sleep time exclusion, you know, I don't know about you, but I'd want to make sure that my clients or whoever was paying the bills is aware that that exclusion will be negated if the caregiver is interrupted and doesn't get at least 5 hours of sleeping time that is free from interruption. Because you don't want to have to bill that client and you know, have some customer relations issues over all of that time, which would then be paid at time and a half. So you really need to, I think, fully disclose that so that people know it could happen. And obviously, you'll need to monitor that moving forward to determine if the care plan for the client changes to the extent that they're up, you know, several times a night where they weren't before, and that could really diminish your ability to use this exemption. Finally, under Wage Order 15, there's an exclusion or credits that can be taken from employee pay for meals and lodging. It's not a ton of money. It's probably, you know, $20, $30, $40, you know, per week, something like that. But it's all outlined for you nicely in Wage Order 15. So go ahead and pull out your copy from the shelf or get it from the DIR website, and you can see what types of credits can be taken for providing meals and lodging to your live-in employees. Okay, so we are at the point in time where I have tried to respond to the lingering questions received prior to this webinar. So at this point, if you haven't already, feel free to go ahead and submit your questions to us using the question or the chat feature. I've got a couple of questions that have come in, and I'll try to respond to these as completely as possible. We have a question about payrolling companies. Are payroll companies prepared for these changes, and what should I be doing to ensure that they will pay employees appropriately? Well, you know, We have been in communications with our payroll provider and our software applications provider for quite some time, and of course they were aware of this change, hopefully. I mean, they were certainly at the time that we became aware of it. So they have been scrambling to ensure that programming is appropriate to pay our employees under these new laws. For those of you out there who run your payroll through a payroll provider and or have scheduling systems for your caregiver staff, you should already be having these conversations with them to ensure that they are prepared to accurately calculate pay under the overtime provisions as of the date of the change. Programming takes time. I know that our providers are scrambling. We don't even think we're going to be able to test it for a little bit here. So it's going to require a lot of additional review and testing to make sure that everything is applied correctly. So we're coming down to the wire. So if you or your agency have not had those conversations yet, I urge you to leave this call right now and get on the phone with them to make sure everybody's on the same page. I'd also suggest, if you can, I talk about trust but verify. If your payroll provider, your scheduling system provider says, yes, it's done, it's handled, you're good to go, trust them, but verify through asking them to run, I don't know if you can run a mock payroll or run a few scenarios so that you can have an assurance on your end that it is actually working the way that they say it's working. So I'd ask them to give you some time to demo that or to test it out. The other thing that I think we really need to consider, and this was sort of an aha moment for us as we've been talking with our software vendors, is that January 1st falls in the middle of a week. It falls on a Wednesday, I think. Is it Wednesday? Yeah, it falls on Wednesday. And so unless you have you've established your work week as a Wednesday through Tuesday work week, this change is going to fall somewhere within your existing pay period. So you've got to be planning for how am I handling that change in overtime law in the midst of a pay period. So am I straddling personal attendant exemption for a few days during the week, and then the triggers flipped, and then we move into overtime not being exempted? Have those conversations if you haven't had them already, because you want to make sure that you handle that appropriately. I see. I love the questions and the comments. I really do appreciate them. An individual has shared with us, good luck on the sleep and meal exemptions. You will see your former employees in a class action lawsuit. Right. We know that where exemptions exist, it is up to individual employers to determine their risk management strategy. And some of you may have a more liberal feeling about risk. Some may be more conservative. So we are going to see probably a variety of responses in the home care industry around how they offer and how they pay and how they provide 24-hour live-in care to their clients. I can say that once you've been through a wage and hour lawsuit, sometimes your risk management strategy changes. So just be mindful of and agree to what your strategy is going to be in this delicate area, because certainly we don't want to be subject to any lawsuits. Let's see, some other questions coming up. This is a great question. This is a really good question. Why can't we just make caregivers salaried and avoid the whole overtime payment issue? This is a great question, because I think that this is an area where folks can get confused around wage and hour law. I should mention that employers can pay anybody. They can pay any employee on a salary basis. A salary just means that a person is receiving a fixed amount of pay for whatever that relevant time period is, a week or bi-weekly period or whatever, regardless of the hours worked. So you can pay anybody a salary. But paying on a salary basis in and of itself does not exclude an employer's requirement to pay overtime. So just because you're paying a flat salary and you're saying that the person is salaried does not mean that they are legally exempt from overtime payments. Many of us are aware who have employed, different classifications of employees that you need to look at what the person's duties are to determine if they can be exempt from overtime under the FLSA. Common classifications of exempt employees are the professional, administrative, and executive employees who can be exempted from overtime if their duties fall within those classifications. There are also classifications for outside sales people, computer professionals, and a few other groups, but they have to meet the duties test under one of those classifications to be entitled to freedom from overtime payments, I should say. They also have to meet the minimum salary requirement. So there's also, in this two-pronged example, there's also a minimum pay requirement. So you can't just put somebody on a salary of $20,000 per year. The minimum salary requirement is 2 times minimum wage. I think that's on a national basis, but let me just speak to California. So it's 2 times minimum wage in California, which means the minimum amount you could pay a person to have them exempt, in addition to meeting the duties challenges, is $16 per hour right now. That's going up to $18 per hour when minimum wage changes in July of next year. So if you are equipped to pay your caregiving staff $16 an hour, $18 an hour starting July 1st of 2014, go ahead. You will have met one of the prongs of the two-prong test for exemption. I cannot conceive of a scenario in which a caregiving employee's duties would afford them the exemption under any of the categories: professional, executive, administrative, outside salesperson, computers, etc. So where you may succeed on the hourly wage that you're paying them to have them exempt, you're more than likely going to fail on the duties test. So that is the reason for making a person's salaried exempt not being a viable solution. Again, go ahead and make them salaried. Anybody can be salaried, but that does not remove your obligation to pay for overtime. Here's a question that comes in asking us, are home care agencies like Live Home and others in contact with the legislature to address 24/7 care, and how can your client help in this effort? Interestingly, and this was just shared with me yesterday by our CEO, we saw in some publication that there was a hearing held on the federal companionship exemption on November 20th. I may or may not have shared that with you in an earlier slide, but they are examining the ramifications. Stakeholders, concerned individuals are coming forward and are examining the ramifications of the potential elimination of the companionship exemption in 2015. So, I don't want to say we're cautiously optimistic that may preclude them from putting the law into place, but what we know is that people are concerned about it and people are making contact with the appropriate parties in the government to express their concern. Now, where Live Home and many, many other agencies, as well as organizations that advocate for the home care industry, what they have done in the past certainly was to write letters and to fax and to call not only our decision makers on a local basis, but obviously all the way up to the governor's office once we heard that this bill was going to be hitting his desk. All of those efforts apparently did not succeed, but I don't think that that means that we as involved parties don't continue. I think the most compelling way, and I'm not a lobbyist, so I don't know, but to me the most compelling way to demonstrate impact to people who don't think about these things is to provide them information about what this is doing, not so much to the organizations, because I don't think government really cares about big or small business, but to the end consumers. You know, what does this mean to mom, you know, who needs 24-hour, 7-day-a-week care? You know, write Governor Brown, you know, send letters, call the office. You know, I think the more that we make noise, the more that they may hear us, and at least we have our position out there. Will it change things? I don't know, but I think if you want to get involved in doing that, certainly I would urge all of us to do that, you know, whenever we can. Another question that has come through the web is something that I think we talked about briefly last time, and that is, can we adjust the wage depending upon the hours in a shift? Example, pay $11 per hour for the first 9 hours of a shift, $10 per hour for the next 5 hours of a shift, and then minimum wage for the remainder. I had shared with those who were on the call 2 weeks ago that this is a very problematic scenario. This is getting into the issue of wage reductions, and while reductions in wages are lawful, we can change employees' wages really at our own discretion. Honestly, we can. But in order to be lawful, these wage reductions have to be bona fide, and they have to be permanent. And so, not having any legal background, but just as a layperson, what that means to me is that the pay reduction, for it to be bona fide, it has to be based upon a justifiable business issue. Certainly, if we are making changes to compensation simply to avoid overtime liability, you can see where that may not be bona fide. That could be actually, you know, unlawful in certain cases. But you know, the bona fide issue is kind of one test, and then the permanency issue is another test. So why would we be conducting either a midweek or a mid-shift pay reduction? That to me doesn't meet the test of permanency. But you know, I tell everybody, again, on that question, contact counsel, because you really want to examine all of your options. I would certainly say that wage reductions where we might say, you know what, newly hired caregivers or caregivers hired after January 1st, our starting pay may not be $9.50 an hour. It may not be $10 an hour. It may be $8 an hour. That's certainly something that I would see as very much less problematic than making some of these wage reductions that people may be considering. So again, evaluate that on a case-by-case, shift-by-shift basis, and consult with counsel before you make changes. And even if you avoid legal challenges, you still need to consider employee relations challenges to that as well. You may have folks you prefer to retain who find that uncomfortable and don't you know, want to continue working under those circumstances. Question, could you tell us again the duties test? Yeah, just to kind of go back to that, and you can find this information. I'm trying to think of the best resource for you. It's probably under, if you go to the Department of Labor website, which is D like dog, OL.gov, you can search for the Fair Labor Standards Act, and I believe that the information about these classifications for exemption rests there. But the common exemptions, the common classifications for jobs to be considered exempt from overtime are professional, administrative, and I'm losing it, executive. So the professional, administrative, and executive classifications are the most commonly used for exempt positions. There is also an exemption for outside salesperson and for computer professionals. Another question, so with the change happening midweek, how does that impact pay within the pay week but before the effective date of the law change? How do we bill clients? Excellent question. First of all, I should say let's kind of take billing clients out of this scenario, because we're kind of addressing the statutory changes, and changes to billing for clients is your internal operational and your based upon your customer service standards. So I'm going to set that part aside. But with a midweek change, and again, I'm presuming this is midweek. If your payroll periods start on a Wednesday, that's the date this law takes effect, so you're kind of not impacted by that. But if it is a midweek, mid-cycle change for you, you need to be cognizant of how your payroll provider or how you are applying the change to the wages based upon the effective date. So maybe your payroll cycle, if you're on a weekly cycle, I think it's common in the home care industry to be on a Saturday through Friday payroll cycle. You may have an employee who is exempt under Wage Order 15 for December 27th, December 28th, December 29th, and then they move into the requirement to have overtime paid starting January 1st. Well, it has been discussed in the guidance that we've received for many years here at Live Home, and I'm sure many of you out there have had similar guidance, that when non-exempt work is performed in the same work week as exempt work, the employee, by one employee obviously, the employee hours all should be counted as non-exempt hours for that work week. So when you think about this change, you may want to think about, how you are staffing folks and what you were talking with your, clients about if you're going to make that change to the payroll earlier than January 1. Just be aware of that and talk with your folks internally and make sure that you're prepared to handle that midweek change. That's a significant thing that we kind of just fell upon as we were going through our planning process, and we've had to, make sure that we're making appropriate adjustments and allowances for that. Another questions come in: can you pay different wages for different clients? Certainly. I think, what we see in home care is that, we employ an awful lot of caregivers or personal attendants, but their job responsibilities vary dramatically based upon the care that is needed by the client. So I could see a case where a particular client who needs more intensive care, possibly needs greater assistance with their ADLs, you may pay a higher wage for that client because you need a more skilled professional caregiver to work with that individual than someone, say, who is reasonably ambulatory, engaged, and just needs somebody to kind of be with them and observe them for safety for a number of hours per day. I would certainly see where that could be paid at a lower wage. So nothing in any of these laws tells us that we cannot pay differently for different jobs. So as far as I'm concerned, that doesn't change. Even with AB 241, it's really where you're talking about, caregiver A is working with client A under, a particular scenario, and then that scenario you as an organization want to change on January 1st. That's where you really need to be, evaluating what the options are and partnering with counsel to make sure that you're not going to run afoul of any wage, potential wage issues. Let's see. I think that let's see. I'm seeing another question. I don't know if I already addressed this, but I'm going to read it and make sure I understand it. Can we pay a lower wage for high hours week clients and a higher wage for lower hours lower week clients? Again, I think that kind of gets into the realm of, are you changing wages in order to avoid overtime liability? But, remember, in our industry, think about those unattractive shifts, 2-hour shifts, 4-hour shifts. Those are generally very hard to staff. people don't usually want to work just a few hours. They want to work as many hours per day as they possibly can. So I think we do see that we will pay a higher wage in order to induce and attract our caregivers to work that short shift and to make it financially feasible for them. So you might say, you know, this is a 4-hour shift and we've got to pay this shift at $12 an hour because, you know, we can't get anybody who will come in and work that shift for minimum wage. That, to me, meets the criteria of bona fide, and so long as you're kind of doing that consistently with that client, you know, I wouldn't see that as terribly problematic. I think we're already doing that, like I said, in this industry. We need to provide an inducement for our professional caregivers to take the less attractive shifts, and where we can say that that is the reason we're doing it and it's not just that we're trying to avoid overtime, then we should be able to do that. Okay, well, you know, I'm really surprised that we've kind of, you know, we're almost at the top of the hour here. I'm very happy that as many questions came in as they did, and I hope that this has been helpful to folks. I want to make sure that everyone is aware that this podcast that has been, webinar that has been recorded will be posted on the Live Home website probably a couple of days?
By tomorrow.
Actually by tomorrow. So by Thursday, we will have this webinar up and available for your listening pleasure if you'd like to review it. There is also a brief, about 11 or 12-minute podcast that is available on the same topic, and it's available on the website. And for those of you who just want, you know, maybe to pass it along as a resource to individuals who just want a high-level understanding, just an awareness of the law, but they don't want to sit through the webinars, that's probably going to be a pretty good little snippet for them to enjoy. So you can find that podcast as well, available on the Live Home website, which is livehome, livehome.com. Thank you, everybody, for your time today. Any follow-up questions, shoot them my way. I've been getting individual emails, and I'm happy to try to answer questions wherever I can. Good luck as you move into the holiday season with the planning around this, and look forward to speaking with you all sometime in the future. Thanks again for your attendance.